Good morning, everybody. That music is so mellow. I was daydreaming away thinking, oh, man, why do I feel so good? Workday. I should be stressing out about what it's it. There. Oh, and the way that does that downer thing, that's just sort of like the judge coming on the bench in the middle of a pleasant daydream. Okay, time to get back to work. And so I am back at work. Welcome back to Law and Legitimacy. I'm a little scattered today, getting ready to give closing arguments in a sex assault case this morning. It's got a hard stop at 8:30, so let's get right to it. Mike reminds me that we haven't talked about a recent cert petition that our office filed, a petition for certiorari to the United States Supreme Court. Since one of our functions in this podcast is to educate people about the law, I thought I'd explain a little bit about Supreme Court, United States Supreme Court practice to you and what it takes to get a case to the Supreme Court. The bottom line is it's almost impossible to get a case heard by the United States Supreme Court. And it's very difficult to predict which petitions are filed will be heard. The Supreme Court occupies the top of the legal pyramid in the federal system. As we've told you before, the judicial branch is one of the three separate and coordinate branches of government, obviously with the executive branch and the legislative branch. And it's the court's function to make determinations about what the law is. And as the United States Supreme Court famously said, and I believe it was the case of Marbury versus Madison, it's the Supreme Court's role to say what what the Constitution is. They get the buck stops there, and hence the origin of the concept of judicial review. Judicial review is a concept that is intuitively obvious to me, that someone has to make a final determination about what the law is, and that should be the courts. But it's really not obvious at all. If you've got three separate and co-equal branches of government, and the executive branch says, yeah, well, that's your opinion. My opinion is otherwise. What are you going to do about it? I enforce the law, and therefore I'll pocket veto this, and I won't do it. That is largely the British experience. And judicial review is not as big a deal in Great Britain as it is in the United States. But in the United States, it is the Supreme Court that sits atop the pyramid. And the way it works is as follows. For the overwhelming majority of the case, the Supreme Court has very limited original jurisdiction. That is the right to hear a case in the first instance. But for 99.9% of cases begin in the district court. A person who is aggrieved, that is, who has a case or controversy that is justiciable, that is, that a court can address and provide a remedy for, brings a complaint into the district court. As Mike and I talked yesterday, there are various screening mechanisms to get rid of those cases. A motion under Federal Rule of Civil Procedure 12b-6 could dismiss a criminal case for failure to state a claim. I like to use this example with clients. If I were to file a lawsuit against my mother for giving birth to me with a big nose, thus resulting in a lifetime of kidding and ridicule, claiming emotional distress against her for wrongful birth, all the facts that I plead might be true. There it is. It's a little too big for cosmetic purposes. I am the recipient of a lot of comments about it over a lifetime, and it has scarred me in ways that have fundamentally shaped who I am. Whether I'm entitled to a dime for that, well, let me take my case to a jury. If I were to file that writ, it would be dismissed. Even though all the allegations are true, it's a complaint for which no relief can be granted. The law does not recognize that as a cause of action. So once a case gets into the district court, it might be dismissed. It could be litigated. That is fought through to a judgment, a final conclusion by the district court. But there will come a time where the district court's work is done. It will either have dismissed the action, had a jury, rendered the jury's verdict into a judgment. And at the point the district court is done, the litigants have the ability to take an appeal. And they can take an appeal to the second to the second level of courts, which is the circuit courts of appeals. There are 11, the country is divided into a number of judicial regions. We have 1st through 11th circuits, plus the DC Circuit Court of Appeals for the District of Columbia, and the federal circuit. These judges are the intermediate level of appeal. They can review errors of law from the district court below and make conclusions that a given rule works in one way rather than another. Or that a law is applicable in one sense, but not another. And those circuit court decisions are binding within their circuit. So a federal a decision in the Second Circuit, where I reside, Connecticut, New York, and Vermont, binds all the district court judges in the Second Circuit and is mere persuasive authority outside the Second Circuit. What happens when the circuits disagree about a question that's likely to recur over and over again? Then there is confusion in the law throughout the land. And that's the sort of case that the United States Supreme Court will hear. But the United States Supreme Court doesn't select its own docket. Litigants come to it. And you file in the Supreme Court a request to be heard. It's called a petition for a writ of certiorari. And if you're viewing, you see one of ours on the screen right now. And basically what we're saying to the United States Supreme Court is that a district court of appeals made a legal error. And that legal error is so significant, you, United States Supreme Court, should do something about it. You should permit us to file merits briefs. You should permit us to come before you and argue that the district court got it wrong. The Supreme Court used to hear as many as 110 cases a year. I think it's down to 60 or 70 now. And there may be 5,000-6,000 petitions for certiorari filed in a year. So the bottom line is there's not a lot of chance on any given petition. If there's a split in the circuits, one says it tastes great, the other it's less filling, and what the characteristics of the item are important enough the Supreme Court could hear it, but you've got to persuade the court that the issue is important. So we filed a petition last week involving Edward Lang. Edward Lang is one of the January 6th insurrection defendants, and his case takes an unusual route to the Supreme Court. Lang is a defendant. He is charged with federal assault on peace officers for his conduct in January 6th. Lang contends he was acting in defense of himself and others when officers unlawfully and violently attacked protesters. The federal government says he used unauthorized violence against police officers. There'll be a jury trial on that topic, and Steve Metcalf, his other lawyer, and I will try that case in Washington, D.C., probably in October. But before trial and before I got involved in the case, Steve Metcalf filed a motion to dismiss one of the counts in the indictment. And that count is that Lang had corruptly obstructed an official proceeding. And Metcalf's argument was that the statute he was charged with pertains to manipulation of records in financial crimes or manipulation of evidence in adjudicatory proceedings. It arises under a federal statute known as 18 United States Code 1512, which had a loophole in it that was closed after the Arthur Anderson prosecutions, so that people who that people who mess with evidence in official proceedings can't escape through loopholes. And so Section 2 of the Act says, forget what Section 1 is, altering, hindering records. If you otherwise corruptly attempt to obstruct an official proceeding, you're guilty of breaking the law. Well, the question that Metcalf presented is, how in the world did a crime that was intended to combat evidence-related tampering or tampering with official proceedings with a corrupt state of mind for some personal benefit, how did that statute end up being applied to a guy who used force against a cop? It's just a poor fit. And so he filed a motion to dismiss the indictment, and the district judge agreed. It was Judge Nichols. Judge Nichols dismissed in the Lang case and in two others. The three of them took, the United States government then took what's called an interlocutory appeal, an appeal before the final judgment to the D.C. Circuit, and the D.C. Circuit disagreed with Judge Nichols in a fractured opinion that's hard to understand, frankly. And so we are taking so the 1512 count goes back to trial, maybe. We filed a request to review the district court's opinion on the grounds that this is a misapplication of the law, that federal prosecutors who have the authority to select charges to bring against the defendant are limited by what those charges were intended to cover and by the plain meaning of the statute. And in this case, the statute was intended solely to affect evidence-related crimes or people who corruptly try to disrupt an official proceeding. That's not what Lang was up to that day. His crimes, if there are crimes at all, were adequately covered by other statutes. When federal prosecutors sought to use this statute, what they were really trying to do is enhance the penalty, because the penalty for the individual counts Lang was that fit the crimes alleged, assault, is 10 years, but the obstructing an official proceeding is 20. And so, we're asking the Supreme Court to review it, not because there's a split in the circuit, but because in the January 6th case in context, prosecutors have shown a remarkable ability to stretch the law to make a point. And that point, we fear, is likely to chill dissent in this country by terrifying people about appearing in public protests, for fear that if something goes wrong, they'll be charged with obstructing an official proceeding and face up to 20 years in prison when lesser crimes could have been charged. So stay tuned on that. We filed the petition. Yesterday, we got a docket number for it. It's now pending on the Supreme Court docket. The United States has until, I believe, August 11th to respond, and then it will be calendared. It'll be placed on a calendar for the Supreme Court to review, and they'll probably make a decision about whether to grant certification sometime in October or November. If certiorari is granted, then there'll be merit briefs, and the case will probably be argued in the spring of 2024. Realistically, the odds are against us. This is the first January 6th petition to reach the United States Supreme Court, and it only does so because of the interlocutory nature of the appeal by the government. And you're saying, well, that's the second or third time you've used that phrase. What does that mean? In the law, there's something for appeals, there's something called the final judgment rule. And usually you can only appeal a final judgment. But in a criminal case, when the government loses a pretrial motion that deprives it of the right to be heard, it can take an interlocutory appeal because without violating double jeopardy, because otherwise the government would never have a chance to have its case heard at all. So while Lang has other charges pending, this charge has been stripped out for independent consideration. So it's complicated stuff, but it is.
Look, we have a comment from Severe Conservative, and first and foremost, good morning, everybody. Love the energy. We've got a lot of people in Rumble this morning, which is a nice change. In the Cloud, Aperture of My Soul, Matthew Kyle, High Society, all over there. In the Cloud, I want to recognize you. Thank you for the dollar donation for the rant. And I think that was just to demonstrate to a couple of other people there in the chat that the feature over there works. And the feature that we're talking about is just the tipping feature or the support feature, which is integrated through locals, right? So if you hit the red join button over on Rumble, you will be taken to Law and Legitimacy's locals page. And I think that sort of solves the problems that we were trying to address some weeks ago, having issues with people being able to support directly in the chat there. We've got Rachel Perry Goff, Uncle Pat, Severe Conservative in the chat this morning. Freedom Lover was the first here. We won't have Luttrell. He said on the solo stream, Norm, that was the only day on Monday that he was going to be able to make it live. So he'll be catching it after the fact, and you'll have to do without interacting with Luttrell for another, 4 or 5 days. So,
Luttrell, we miss you. We miss you, Luttrell. The morning is not complete without a good morning, Luttrell, before we're even on the air.
It's me again. Yes, it looks like and thank you in the Cloud for clarifying that stuff for everybody over on Rumble. I put Conservative has on the screen there. Gorsuch has been sympathetic to challenges to vague statutes about immigration. I think that ultimately this is just sort of, I think that we're hoping that this court is going to be sympathetic to I guess what is considered in this case and what's on the screen as well, breathtaking application of statutes. So sort of I know it's not the same analysis in terms of vagueness to clarify, but in terms of a misapplication, because that's ultimately what the breathtaking legal standard of the precedent is referencing there, is where the federal government is using a criminal statute in a manner that it was not designed legislatively to be in a manner that it was not designed legislatively to be applied. Is that correct, Norm?
Yeah, it is. And it's related to the vagueness concept. So the due process clause of the United States Constitution has been interpreted to require a fair notice requirement. In other words, when a statute is enacted that prohibits certain conduct, it has to fairly notify the world about the conduct that is to be prohibited. And that has to do so in language that ordinary people can understand. One of the most powerful implicit arguments why the Supreme Court should hear the 1512 case that we brought on behalf of Mr. Lang is if you try to read the appellate court decision from the DC Circuit, you've got an opinion for the court and a concurring opinion, and it's a 3-judge ruling. So you've got an opinion that decides the case that's written by Judge Pan, an opinion agreeing that Pan got the right conclusion, but for different reasons, and a dissent by Katsas. The reasons they have for voting don't agree with one another. And so we've got 3 very learned judges on a court a heartbeat away from the United States Constitution looking at a statute they can't agree on what it means. How's an ordinary person supposed to understand what it means? There's something in the criminal law called the rule of lenity, the rule of leniency. When a statute is susceptible to multiple interpretations, lenity or leniency requires that the interpretation that most benefits the defendant be granted. We'll see what happens. I want to follow up on a comment from Severe Conservative. Yes, it takes 4, although there are 9 justices on the Supreme Court, and to win a case, you must have a majority of those voting. You don't need a majority of the 9 to get certiorari granted. It takes 4 justices. And so we will see. Carta says, I indicate a lack of confidence going into this process. Curious as to why. Just on a numbers game, Justin. I mean, if there are going to be 5,000 petitions filed and they're only going to hear 60 or 70 in a year, I'm swimming upstream. Also, this is a preliminary case. It's on a motion to dismiss, not after a verdict. And it's the very first petition of this kind filed. The Supreme Court may well say, this is interesting. We want to know more. Let's see what happens later. The Supreme Court picks cases when they think the cases are ripe, when there's enough information and an adequate record for the court to render a decision. And, how they make those decisions is largely a matter of judicial taste and what different judges look for. As Severe Conservative noted, Gorsuch has been sympathetic to challenges involving vagueness in other contexts. We're hoping that given the importance of these January 6th prosecutions and their historic nature and the unprecedented manner in which the government is stretching this law to cover something that it wasn't intended to fit, we're hoping that the Supreme Court will step up and do the right thing.
Well, and if you don't mind taking a couple of moments here, Norm, to at least to connect this to a chilling effect on the First Amendment. So I've put the section of the United States Code, the criminal code that's being applied against your client, Edward Lang here. And I think that, I referenced the legislative intent of that criminal code. Can you talk about, and just to clarify, this is a completely different criminal code than was applied to various co-defendants, Proud Boys, in Norm's representation of Joe.
Oh, no, that's not true. This is a statute that was applied to the Proud Boys as well. And there will be an appeal.
For seditious conspiracy, however.
Well, this is a different, this was in addition to seditious conspiracy, but this was charged in the Proud Boys.
Okay, my mistake. So it was, but this is what we emphasized on this stream, rather, is with respect to the Proud Boys, and in particular Joe Biggs, was the application of seditious conspiracy.
Oh, absolutely. Yeah, we've talked about that, but not about this. So look at the statute. This will, it's 18 United States Code. That's the USC, section 1512, C1 and 2. C1. Whoever corruptly, what does corruptly mean? The courts had a lot to say about that. According to the Judge Pan, corrupt just about anything. If you broke the law, it must be corrupt. Judge Walker said, no, corrupt means some personal benefit to yourself or a third party. Whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity available for use in an official proceeding is guilty of a crime. So that was what the law was prior to the Arthur Anderson and Enron prosecutions. Some people got away. The statute didn't apply to them. They did things that affected official proceedings, but it didn't fit the definition of Section 1. So, this was called the Arthur Anderson loophole in the law. And so Congress closed the loophole by adding Section 2. And it says, and you read that term "or" is disjunctive. Whoever otherwise obstructs, influences, or impedes any official proceeding or attempts to do so is guilty of a crime. So the debate is, what does that otherwise mean? Does otherwise it pertain to anything that can affect an official proceeding, or does it have to be something that is evidence related? And does the meaning of section 1 cast light on what section 2 intends and entails? And that's one of the things the court has to decide. Now, the chilling factor that Mike raised, I mean, again, a jury decided against me in the Proud Boys. We did a post-trial brief on this. We're going to take an appeal to the D.C. Circuit. I'm going to do my level best to get it in front of the United States Supreme Court. Here's what here's our impression of what happened. The Proud Boys came to Washington with thousands of others to protest what they called "Stop the Steal." They had a belief that the election had been stolen. They were inspired to believe that by none other than the then president of the United States, Donald Trump. They appeared in Washington. They had a right to appear in Washington, to peacefully assemble. They had a right to petition for redress of grievances, and they had a right to be heard. Those are First Amendment rights. They gathered with others and marched. I don't think the government never proved at trial that there was a plan to engage in violence that day. In its closing argument, the prosecutor who gave the closing argument said the conspiracy could have been formed at the moment of the first breach, the moment the first barricade was crossed, that it could have been instantaneous and implicit. So our view is, you've got people at the barricades, angry, protesting, doing what the First Amendment permits, and some hothead crossed a line and others followed him. Is that a conspiracy, really? Or is it merely a trespass? And our view is it's merely trespass. When there was no intent, there was no plan, there wasn't even really an objective to do anything other than what the First Amendment prohibited them to do, which was to stop the steal by protesting. So this statute that permits Congress to say, if you otherwise obstruct, influence, or impede an official proceeding, is right on the line of protected activity. People who were in Washington, D.C. on January 6, 2020 wanted to impede an official proceeding. They were calling on Mike Pence not to certify the election. That's protected speech. That's protected activity. What was not protected was crossing a barricade and storming the Capitol grounds. If that wasn't planned, there was no conspiracy. That is our argument with respect to the conspiracy counts. If they crossed a line, they weren't engaged in a 1512 C2 charge because this was not what Congress intended. They were at most involved in trespass, rioting, or breaching the peace.
Yeah.
And so
from a layman's perspective, I think, and I'm not a layman, I'm obviously an attorney, but by comparison to your level of practice and experience in this realm, I might as well be, right? But I think that helps me communicate to our audience a little more effectively, I guess, the nuance behind why this is so important. And it is that this breathtaking standard, or this breathtaking application of a federal law, federal criminal code provision, necessarily needs to be understood by the public writ large as to how it applies. And in this case, we have, and we've talked before on this stream ad nauseum, thousands of current January 6th defendants, right? And we have seen Congress allocate more funding to the DOJ for additional charges stemming from January 6th, right? For potentially 1,000 more defendants. And if this specific code provision is being used as sort of the linchpin, and applied in a manner that was not intended by Congress, well, then what you're talking about, Norm, is necessarily that people do have a First Amendment right to protest, right? They have a First Amendment right to assemble, right, in public spaces, to gather and to petition their government for redress and to voice their grievances. But if there's no way to predictably say this sort of behavior runs afoul of First Amendment protections, the public writ large is going to be disincentivized and speech is going to be chilled. No one is going to risk 20 years in prison to show up somewhere where by their mere presence alone, they can be charged with a violation of a federal criminal statute like this one.
Yeah, and that is the argument. And we tried to make it with Judge Kelly in the Proud Boys case. He disagreed. The issue is preserved for appeal, and we will take the appeal when judgment enters in the Proud Boys cases. But we saw evidence of what Mike's talking about on press or anecdotal reports at Trump's various arrests in New York and Florida. People were afraid to go to the protests for fear that they would be arrested.
Perfect
and they
example.
were afraid because, if you're standing there on the front line and somebody does something wrong, are you a co-conspirator with them? And of course, one of the comments I loved making in this brief was, this is the functional equivalent of saying that every person who marched in a Black Lives Matter march and said no justice, no peace is guilty of arson because some other hothead threw a Molotov cocktail at a building or vandalized a building. So, speech, violent speech, antagonistic speech, passionate speech, that is a core First Amendment value. And in the context of politics, that's the heartland of the First Amendment, and it's the primary reason the First Amendment was passed. We think that what's going on in the Justice Department right now is unconscionable and resembles the Palmer Red Scare days or the prosecution of communists in the 1950s. And we're trying now to criminalize and disincentivize dissent. And the Supreme Court needs to step up and come to the rescue. So there you have it.
Well, and I think this is, I did reference this again on the stream, on the solo stream, that this has been filed. And you also, I guess, filed your appeal. The J6 case on behalf of Joe Biggs as well. That was
we filed post-trial motions. We asked for a new trial in part because of the unprecedented nature of publicity in that case, and I'll say more about that in a moment. But in part because the evidence was insufficient to support a conspiracy case. But as to the new trial thing, this has not received the attention I think it deserves. But it's my case, so I think it deserves attention, and it's our podcast. So here comes the attention. There are rules about pretrial publicity, and lawyers are prohibited from saying things that might reasonably affect the fairness of an adjudicatory proceeding. Some courts have held that trial participants also fall under those restrictions. While we were picking the jury in the case of United States of America versus Joe Biggs et al. And others, Congress was releasing its January 6th report, which called out the Proud Boys for organizing the insurrection and claimed that they were doing so at the direction of Donald Trump and named my client, Joe Biggs, as a violent cooperator. And what's more, made statements about Joe Biggs in an official government document that weren't true. And everybody in the trial knew it wasn't true, to wit, that he threatened someone at the protest with a gun if the person didn't cross the barricades. Even the United States government, the prosecutors didn't believe that was true, but yet you've got Congress telling the world that during jury selection. As if that wasn't bad enough, on the eve of closing arguments, we've got Joe Biden writing the J6 protests and comments about MAGA extremists, aka the Proud Boys, to announce his reelection campaign. So we've got the head of the executive branch, the head of the party that is suing or who is prosecuting my client, President of the United States of America, and the caption is USA versus Proud Boys, or Biggs et al., I should say. You've got Congress, a coordinate branch of government, doing the same thing, and you're trying the case. If I had stood up on the courthouse steps and knowingly said things that were untrue about the United States government or its witnesses during this trial, I would be in a world of trouble. If Joe Biggs did it, he would be in a world of trouble. Why is it that when Congress does it and Joe Biden does it, it's okay? It's not. And so it seems to me that if we're going to treat courtrooms seriously as a place where people are entitled to a fair trial, we need to treat each party as equal. And when the United States government pursues my client, it's responsible for the conduct of its spokesperson, including the president and including Congress. And if you're going to say, as the trial judge did in this case, oh, well, they're not parties, that's BS. They are parties. The caption read United States of America versus my clients. And if it's a schizophrenic government that's out of control, my client shouldn't suffer as a result of it.
That's right. And there's a T-Girl, nice to see you in the chat this morning. T-Girl says they are trying to have Trump removed from ballots, citing the 14th Amendment, Section 3. Is prosecution of the J6 defendants necessary for this to happen?
I think they would need to find that Trump was a participant. And, we had predicted after the Proud Boys trial that Trump would be indicted as early as June. Well, here it is, July, in J6 related material, and he's not been. So we got one wrong this year.
Well, but what I think, what I was in the chat here, and because T goes on to say, I was under the impression that the 14th Section 3 had been used following the Civil War, so not necessarily unprecedented. But what I was saying to her, Norm, is in prior streams, we've talked about the January 6th defendants as almost experimental cases and sort of creating the creation of new precedent that then could be wielded in a more effective and scoped capacity to prosecute President Donald Trump, right? And so the thousands of reps that they are now getting, they're obviously, lots of time between now and when the Civil War ended and the application of the law then and as it's being applied now, right? And so I think that when I say unprecedented, T, it's not necessarily that things have not been misapplied in the past or used historically as a tool, but it's unprecedented that we are watching such a closely scoped matter on January 6th used to apply basically the full regime of a federal criminal statute against a sitting or a former president of the United States who is also running for president in 2024, right? It seems pretty obvious at this point that this is the penultimate case, the penultimate prosecution that's forthcoming in and among all the stuff. We still haven't seen anything out of Georgia, Norm, because we talked about 4 cases, right? We talked about New York, talked about the confidential documents cases out of Mar-a-Lago. We talked about the Georgia elections issue and that prosecution. And then we talked about seditious conspiracy and a DC jury that would be seated to prosecute Donald Trump for that.
Well, listen, yeah, that's true. So keep an eye on that. But Mike, I got to run. I got a judge waiting on me soon. So I got to get over to court. So listen, folks, thanks for tuning in. We'll be back with this and more. I still want to talk about the dissolution of Netherlands government as a result of a dispute about what to do about immigration and whether this proves that Jean Raspail in Camp of the Saints was a prophet. I know that Raspail is a controversial author. I've read the book twice. I think he's got something to teach us.
And we've also got Tucker on Twitter, episode 9 with Tate. That's something that I definitely want to talk about. So let's come back tomorrow, Norm. Now that you've got closing arguments on the books today, let's come back tomorrow and spend some time with this. I think that the interview that was posted yesterday, and as it says on the screen there, 40 million views in about 14 hours. This is an extremely
extraordinary. Yeah,
I mean, it's very important, and I'm moved by the content and the substance. Made it about halfway through, so maybe this is better. We'll come back tomorrow. We'll talk about this in great detail. But Norm, in the meantime, go get them. We've got a new handle on Twitter. How many Twitter followers is our goal over the next month, Norm? How many Twitter followers do we want?
We want 140 more. We've got 362, I think. If we get 500, Mike will tell you we get like bells and whistles on Twitter. So we need 160 people to follow us more. All right?
Yep. Let's do it. Let's get to 500 followers on Twitter. Please follow us at LawPod Daily and share. And we'll be back here tomorrow. Norm, get out of here. I'll see you.
Glenn Wolf, thanks for listening. I got your email.
See you.